Good morning, this is Richard Murphy on the 30th September 2013, and I've been asked by a journalist some questions about offshore tax havens and what's going on in them. And I thought rather than spend ages on the phone to him alone explaining my view on these questions, I'd literally turn on this recording and talk about them and share them more widely. His first question is about David Cameron's recent comments on the fact that, as far as he's concerned, the UK's crown dependencies and tax havens, overseas territories are no longer tax havens. And he's said this in the light of the promises that they have made to take action on beneficial ownership and the agreements they've reached to enter into FATCA-style agreements with the UK and the USA. And his point is, am I more cynical as a result about, or sceptical as a result, about the prospect for real change coming up with regard to tax haven activity? And the answer is, of course, yes, I am. It would be impossible to deny that I'm disappointed by what has happened. Now, I was surprised back in December and January when David Cameron, in the wake of the Google, Amazon and Starbucks debacle in front of the Public Accounts Committee, jumped on the bandwagon and said that he was wholly opposed to tax avoidance and that he was going to make it the focus of the G8 summit, for which he was, of course, responsible. Now, the language he used then was decidedly robust. He was condemnatory of the whole structure of tax avoidance, the use of tax havens, and said he was going to stop it. At the G8, let's be honest, he made some progress, by no means as much as anyone would wish. Remember that the Luccan Declaration was full of shoulds and not wills. There was not a single commitment which was actually obligatory. Everything was a should. And so, obviously, at that point, we were worried about what was really going to happen. Well, now we've seen the backpedalling begin in a serious way. It is impossible to reconcile the G8 declaration and the demand for transparency that it made and the demand that it made to end tax haven abuse with the extremely weak commitments that have been made by the UK's tax havens. For example, the British Virgin Islands has written an action plan on how it will deal with the demands for improved exchange of information and the disclosure of beneficial ownership, saying basically, but we already do it. Now, there is no state, frankly, that does less to help the disclosure of beneficial ownership in the world than the British Virgin Islands, where, frankly, the company registry is chaotic and secrecy is absolutely complete. So David Cameron's comments are very clearly reversion to form on the part of his party, perhaps on the part of the UK government as a whole, in saying there is no issue to address here. That's deeply disappointing. And yes, it does indicate that real progress is going to be harder. The second question the journalist asked me is this reminiscent of what actually happened in around 2002, when, frankly, the whole campaign against tax havens, which had begun in 1998, at the beginning of the Labour government, at the tail end of the Clinton regime, suddenly began to fall apart because of the rise of the power of the Bush administration, which was then saying that it thought tax havens were a great thing, undermined the whole OECD process, which was looking to tackle harmful tax practices, and basically left the OECD having to get small tax administrations, the tax havens of the world, to sign up to tax information exchange agreements, which we know to be almost meaningless and almost impossible to use, let's be candid, as the only weapon left to say that it was making progress on this issue. And the answer is yes. To the journalist in question, it does seem to me absolutely certain that what we're seeing is a new round of paper-filling exercises. The paper in this case and the filling in this case is legislation. So there is a demand made that an agreement be put in place. So a information exchange agreement will be put in place. There is a demand made that there will be a register of beneficial ownership, even though it will not be accessible. The difficulty is that what we know is happening, and the French have recently, for example, indicated their significant concerns about information exchange by blacklisting 3 more tax havens, including Jersey, as non-cooperative as far as they are concerned, even though they have signed such tax information exchange agreements with France. The concern is that whilst the paper is put in place, the practice does not follow through. Now, I've called this a process of constructive non-compliance. What it looks like is that they're constructively engaging, and behind the scenes they're doing absolutely everything they can to make sure that they are not delivering the data that is needed to make sure that information exchange takes place. And the reason for information exchange is very simple. The reason why we need information exchange is that the more information that is automatically passed to a taxpayer's domestic tax authority, the more likely it is that they will declare the income that they have on their tax return. The rate of compliance goes up, the rate of tax evasion falls, the yield from tax activity, the activity of a tax authority increases, and we have a fairer, more equal society as a consequence, with the overall rate of tax burden on honest taxpayers probably falling, and all of that has to be, of course, for the benefit of society as a whole: law and order, the maintenance of democracy, the delivery of public services, the ending of austerity, and so on. But at the moment, what we're seeing is an excuse being put in place. The third question I'm being asked is, how would an effective automatic information exchange work in a nuts and bolts way? How would the procedures and safeguards that need to be in place to ensure an effective job of catching tax evaders and other miscreants exist? Well, I believe that this actually is really not that difficult. There is a very widespread obsession with talking about information exchange about income. Now, I personally have never believed that that is important. What I believe is absolutely critical to make automatic information exchange work are two things. The first is actually, and rather curiously, a tax information exchange agreement. Now, having just said that these things are utterly useless, and I absolutely stand by that comment, I actually would, in an effective information exchange system, require there to be widespread tax information exchange agreements, because what's also needed is the smoking gun data to make sure that a tax information exchange agreement can be used. The problem with a tax information exchange agreement at the moment is very simple. The applying tax authority has to actually be able to prove the link between their domestic taxpayer and the deposit of funds which should be taxed in that person's name in a tax haven. The difficulty is that in the case of a sophisticated taxpayer, it is highly likely that the person who has deposited funds will do so through a trust, and they may well not be named on the trust documentation, they may not be named as the settlor, there may well be a nominee settlor, there will be, of course, nominee trustees. Those nominee trustees will, through that trust, own a company which will be owned through nominee shareholders, there will be nominee directors, and it is that company which will receive the income. But the domestic tax authority, whether it be the UK, France, Germany, USA, India, any country in Africa, South Africa, any other country, cannot make the application for information exchange unless it can prove that their taxpayer controls that trust, which controls that company, which controls that bank account. Well, of course, that is incredibly difficult. It virtually requires the taxpayer to give the information away before such time as the information exchange request can be made, by which time it's irrelevant because, of course, the tax authority would now know. Now, if we had a proper information exchange system which disclosed the fact that a taxpayer had an interest in what I call a financial structure, in a tax haven, and that information was disclosed to their domestic tax authority, this problem will go away. Let's be clear what I mean. A financial structure could be a bank account, it could be an interest in a company, it could be an interest in a trust, it could be an interest in a foundation, and the interest could be as a beneficiary, as a settlor, as a creator, as a shareholder, as a bank signatory, as the director of a trust, the settlor of a trust, the protector of a trust, you name it, any of those structures. If identified for money laundering purposes in that tax haven, and of course, there is an obligation, which we are told that the tax havens fulfill, to identify who are the real controllers of the structures that are managed within those locations. If that information created for money laundering purposes shows that, for example, a controller of a company, controller in whatever way you wish, whether by shareholding or whether by directorship of a company, in the Channel Islands is in fact a person in the UK, then the Channel Islands, be it Jersey or Guernsey, should notify the UK of that fact. We don't need profit to be notified. We don't need rents received to be notified. We don't need dividends to be notified. We just need it to be notified that they do have an interest in a structure in the Channel Islands. And at that point, the UK tax authorities, and this would of course apply to any other country as well, could look at that person's tax return and say, hey, hang on, we've been told by a tax haven that here this person has an interest in a structure in a tax haven and there's no mention of it on their tax return. At that point, they can ask the taxpayer, why do we have information that you may have income in a tax haven and yet you've declared none? If that person then says, well, I don't have any such interest, the smoking gun exists to use the tax information exchange agreement, because then the UK tax authority could go straight back to Jersey, Guernsey, anywhere else in the world, and say to them, look, you have told us this person has an interest in an account, and yet what you're saying is this person apparently has no income. Could you please now provide us with the full information we require about this account, what it earns, how much it pays, who to, so that we can determine whether tax has been evaded or not, because this person denies any involvement. All the conditions for use of a tax information exchange agreement now exist, and it's very simple. We're not asking about the calculation of income, I stress. We're simply asking about the exchange of information, about who has an interest for money laundering purposes. It's straightforward, it works, it's vital. So the next stage, the next question is there any danger that in the absence of real political will we could end up with a half-hearted, poorly designed, poorly regulated information exchange convention that will provide us with the semblance of transparency but not truly be effective? Look, I've absolutely no doubt that's where we're heading at the moment. I do not think that there is a real political will to create transparency about information exchange. It's quite extraordinary, isn't it, that the UK government is undertaking a process of making inquiry about whether we should discover the beneficial ownership of companies registered in the UK, and yet is asking whether the resulting register should be on public record or not. Well, if we're talking about transparency, having a secret register is a complete non sequitur. It is absolutely obviously against the spirit of the intention of the whole exercise. We have to move to put information on public record to hold people to account for the use that they make of limited liability around the world and the use that they make of trust structures around the world, where it is known, clearly known, widely acknowledged, universally accepted that there is now a problem with the use of those structures in tax evasion. And therefore, the time has come to actually say enough is enough. We must have this information on public record. This is not an invasion of privacy. You can invade somebody's privacy if you demand that personal information be put on public record, and I do accept there is an issue there. I don't think that is a prevention of, by the way, automatic information exchange, but I don't think individuals' information needs to go on public record, at least as yet. But I absolutely am certain that when somebody chooses to use a privilege granted by society, and trusts and companies are privileges granted by society, then they should be held to account for it and they should have their information put on public record. Without that willingness and without the willingness to exchange that data automatically between all nation states, unless there is risk of a human rights abuse at the far end, I do not expect this information to go to Zimbabwe. I do not expect it to go to China, by the way, because there's a death penalty for taxation in China, and that is obviously far too extreme to be considered. But with those exceptions taken into consideration, then automatic information exchange should become the norm, and the disclosure of information on public records should be required. So we are not moving in the right direction there. The final question I was asked, was FATCA the inspiration and impetus for the current G20 information sharing agreement? Yes, it was. I mean, there's no question about that. The change in the US mood on this issue clearly gave rise to the possibility of there being FATCA agreements elsewhere. I mean, I was involved nearly a year ago now in highlighting the existence of the UK demand of the Channel Islands and the Isle of Man for FATCA-style agreements. At the time, people were shocked, but now it's been accepted that this is where we're heading. Without the US initiative, this would not have happened. It's a great shame that the rest of the world couldn't take the initiative for themselves, but nonetheless, that's what was the case. Now we need to accept that the US is going to do this. It will happen. The detailed rules are still being finalised, but we need to follow in their path. And what we need to ensure is that around the world there is effective automatic information exchange to deliver the information that ensures there is a level playing field in taxation. And a level playing field in taxation is not zero tax, it's not neutrality. It's ensuring that each person pays tax in the right place at the right time to the right authority at the right rate, and then we have everybody who's competing on a level playing field. That's the definition of a level playing field. It's eliminating cheating, it's eliminating evasion, it's ensuring that we have openness and honesty and accountability, and providing the information and markets need to ensure that resources are allocated effectively to deliver economic well-being in all countries around the world. I believe that's possible. I believe that's desirable. I think it's essential. And the point is now that the opportunity exists to deliver it, but what we require is the political will to ensure that we get it. That at the moment is absent. That is why campaigners will continue to work in this field, why we will lobby in this field, and why we will continue to point out the deficiencies in tax haven behaviour, including the deficiencies in behaviour in those places that David Cameron has said are not tax havens, when quite emphatically they are tax havens and they are secrecy jurisdictions, which are places that deliberately create legislation for the benefit of people who do not live in those places and who create a veil of secrecy surrounding those people who use that legislation to abuse the laws and regulation of their own country, including those with regard to tax. We're making progress. We've a long way to go. Thanks for listening.